Good morning, good afternoon, good evening, everyone. As you're joining in, it'd be great to see where folks are joining us from. Why don't you, if you feel comfortable, go ahead and drop your name and your location. Introduce yourself in the chat, or at least where you're joining in from. And let's go ahead and get started. Welcome to today's masterclass. My name is Dr. Wanjiru Kamau-Rutenberg, and I'm the founder and executive director of B-WEL, Black Women in Executive Leadership. And the masterclasses are a series of conversations, courageous conversations that are really aimed at zeroing in on those things that Black women may or may not have had opportunity to have conversations about, but things that affect our careers, things that affect our executive careers and shape those careers, but that we often don't get an opportunity to have conversations about. Today's masterclass is a particularly courageous conversation, looking at Black women and legal entanglements, especially with employers, and particularly with employers. We know that we want things to go really great with your executive career, but they might not. And you might find yourself in a moment of entanglement, whatever that shape takes. And so this conversation today is with two amazing employment lawyers representing perspectives from different parts of the world. And I'm so excited for the conversation we're gonna have. A couple of housekeeping pieces. The session is live streamed and recorded, and we are going to ask that you please share your questions in the chat throughout the session. And when we have an opportunity, I might be able to take some questions or shape the questions that I ask to the panelists based on the conversation that's happening in the chat. So please, for those of you who are able to be joining us in the live stream, please engage in the chat and help shape the session. And there's going to be an extensive Q&A session at the end of the kind of content piece of this piece. Let me start with and also please note that the information in this session is for informational purposes only and is not, nor is it intended to be legal advice. You really should consult your own attorney for advice regarding your individual situation. That said, we hope this session helps you get context and even know what questions to ask of your lawyer when you do get to have that conversation. So today we're representing two very different perspectives. One that represents primarily employers, a lawyer who primarily represents employers, and one that primarily represents employees. We're also representing two jurisdictions, the US and Kenya, which, with Kenya as a Commonwealth country, has many similarities to other Anglophone African countries, and of course to those countries in the Caribbean that follow or have a jurisprudence that descended from UK law. We picked the term legal entanglements because these disputes with employers are complicated, confusing, and can just get messy sometimes. So let's go ahead and kick off, and we're going to kick off with a poll. And I've got 3 questions for you. So let's throw up the poll, and everyone please go in and let us know your answers to this poll. I'm going to give us about a minute, 30 seconds to a minute. To those who've just joined, come on in. Look at this poll. We want to just hear from you as we get introduced. Go ahead and fill in this poll. I'm going to give it another 30 seconds for the poll. And for those who've already completed the poll, Why don't you drop in chat, introduce yourself, let us know where you are joining us from, what part of the world you're joining us from. California, we've got someone from Nairobi, Washington, D.C., Orlando, Florida, Samoa, Nairobi, Kenya, Michigan State, D.C. Wonderful to see you all. So why don't we go ahead and get started? Has everyone filled in the poll? Please go ahead and fill in the poll. We've got New York City, we've got London in the house, we've got Brooklyn. Wonderful, wonderful. The time zones here, I should be saying good morning, good afternoon, good evening to everyone. Okay, so we have 83% of you all saying that you felt discriminated against at work. We have another 83% saying that you have not engaged an employment lawyer. And we have 58% saying you wanted to but didn't, and 42% of saying, yes, you wanted or needed to, but didn't. And we've got some short answers. I'm going to try and see those and share those with you. Let me, as we go along, let me go ahead and introduce our speakers today. We have Michelle Lee, who is a partner at Rudy, Exelrod, Zieff, and Lowe. Michelle Lee joined the firm to represent workers in both individual and class action cases to protect workers who've been treated unfairly by their employers. Michelle specializes in a variety of employment law issues, including wage theft, discrimination, retaliation, harassment, sexual assault, and trade secret matters. Michelle has successfully recovered millions of dollars in damages for her clients from some of the largest employers in California. Michelle has tried complex cases in court and arbitration, including serving as second chair in the trial team in the landmark sex discrimination case, Ellen Powell versus Kleiner Perkins, that highlighted the barriers facing women in venture capital and tech industries. Michelle has been recognized as one of the top women attorneys in Northern California by San Francisco Magazine, a super lawyer, and one of Law Dragon's 500 leading plaintiff employment lawyers in the United States. She's a frequent panelist and speaker about employment law issues, as well as her passion for combating bias and fostering diversity in the workplace. Michelle, welcome and thank you so much for sharing your vast wisdom and experience with us. We also have Anne Babu, who's an advocate at Anne Babu and Company Advocates. She is an advocate of the High Court of Kenya, boasts 16 years of dedicated expertise in employment and commercial law. And as the founder of Anne Babu and Company Advocates, she extends support to corporate employers in navigating the intricate landscape of labor laws. Her firm serves an array of multinational and international non-governmental organizations. Anne's daily endeavors involve advising clients on multifaceted employment matters, such as mutual separations, managing performance, disciplinary procedures, and restructuring. Her work extends to conducting training sessions, empowering hundreds of individuals from notable organizations such as British American Tobacco BAT, the United States International University, and Strathmore University on crucial employment law aspects. In the realm of litigation, Anne was recently recognized among Kenya's top 100 litigation lawyers. She represents corporate employers on a spectrum of cases, from discrimination to unfair termination. Notably, she represented the Network of African National Human Rights Institution in a significant pregnancy discrimination lawsuit. Her global recognition by Chambers and Partners and Legal 500 as a leading employment lawyer in Kenya is a testament to her remarkable expertise. Beyond her legal endeavors, Anne serves as board chair of Gold Star Kenya and NABU Global Incorporated, demonstrating her commitment to broader societal initiatives. Again, welcome and thank you so much to the two of you. For agreeing to serve on this. Let's go ahead and get started with the heart of the matter. And I'm going to ask Anne and then Michelle to tell us, what is discrimination? What are the different types of discrimination? And how can a Black woman determine if they're being discriminated against in the workplace? And again, let's start with you, Anne, and then go over to Michelle. Anne, over to you.
Thank you, Wanjiru. It's lovely to be here. So discrimination is unequal treatment on account of unlawful factors. So things to do with race, sex, pregnancy, marital status, health status, ethnic and social origin, color, age, disability. So basically, when somebody is receiving different treatment on account of these factors, which should not ordinarily constitute or give rise to, differential treatment. So the types of discrimination are many. There are as many as the unlawful factors. So we have things like wage discrimination, pregnancy discrimination, harassment is also a form of discrimination. We also have racial discrimination, which is quite common. How do you determine if you're being discriminated against? Normally, it would be because you're seeing that you're being treated differently on account of an unlawful factor. So maybe you've noted that you're receiving less wage than your male counterparts, or maybe than people of different races, or people who are not married. So it's basically that you notice that you're receiving different treatment on account of an unlawful factor.
Yeah, and thanks, Anne. And it is wonderful to be here, and thanks everyone for coming. Yes, I would like to add that just kind of how does it manifest in the workplace? One of the main ones that Anne was raising is wage discrimination. So, for example, you're not getting paid the same as your counterparts who are not Black women or who are not Black, or any other kind of factor. Other types of discrimination can be subtle. Or can be pretty overt. So some types of discrimination that you as an executive in a white collar workplace may feel is you're not getting the same opportunities as other people. Your work is not being elevated or celebrated in the same way. You're being passed over for promotion while other people are given certain opportunities or given more visibility in the organization. And then there's other more concrete things like you've been demoted or ultimately you've been terminated. And the reasons that you think that you've been terminated aren't because of poor performance or because of a reduction in force, but rather, you suspect that it's because of who you are, your status as a woman or a Black woman, as it were.
And moving on from that, Michelle, let me come to you. How do I find you? How do I find a lawyer, and how do I pay you?
Yeah, so the primary way that attorneys in the United States work, at least for employee side attorneys, is on a contingency fee basis. So you usually, at least in the United States, you should be able to find an attorney who can represent you on an hourly basis, meaning you pay their hourly rate for whatever fraction of time you use. So let's say my hourly rate is $600 and you pay, an half hour of my time. More commonly, though, we represent people on a contingency fee basis, which means that we're trying to recover something for you, monetary or otherwise, and we take a portion of that recovery depending on whatever stage of the litigation it is. So you don't actually have to pay us up front. We kind of front the costs for you, and we take out of any recovery our fees. And if we don't recover for you, then you don't pay. And that model kind of arose because obviously most of our clients are in a position where they are not employed. They've been terminated, and that's why they've come to find us. So when you're looking for an attorney, two ways to do it. The best way is to talk to another attorney that you know. Even if that person doesn't do employment law, they probably know other attorneys who do, or have a network of people they can tap into. So referrals from other attorneys are kind of probably the best way, rather than just like
Fantastic. And I'm just really curious, does it work differently in Kenya?
Yes, and notably is the fact that contingency fee agreements are not lawful in Kenya. So it's not lawful for a lawyer to say that I will take 10% of the amount that I'm able to secure for you. In reality, it does happen, but it is actually prohibited under the Advocates Act. So it's more common for a lawyer to say that this is my fee, you can give me a deposit, and then we can agree on pay installment plan on how you're going to pay the balance, with the hope and anticipation that I'm going to secure something in the end for you. And then whatever is left off, we can, I can take part of it from whatever is left off from the damages that you're able to secure. But so installment plans are quite common when you're dealing with individuals. Yeah.
Very important distinction globally. So I think when we're thinking about find out what is lawful in your jurisdiction before moving forward. Really interesting distinction there. Let's keep moving forward. And I'm going to ask both of you, what steps should someone take before contacting an employment lawyer? Let me start with you, Anne, and then come to Michelle. What are the steps to take first? And then I'm also going to ask what follow-up questions on what side of the entanglement you find yourself in. But let me actually ask all the questions and see where you take it. So the overall question is, what steps should someone take before contacting an employment lawyer? For Anne, I'm interested in knowing, what should you do when you're in management and receive a complaint? And then for Michelle, I'm curious, for employees, are there intermediate steps that we can take aside from filing a suit? So let's start with you, Anne. What are the steps to take?
Okay, so if you're a manager and you receive a complaint, you are under obligation to ensure that it is dealt with. So you can't sweep it under the rug. The first thing you have to make sure is to find a way to have it dealt with. So the first thing you'd expect somebody to do is to reach out and see what the grievance policy talks about in terms of what's the procedure for handling grievances. Normally there would be several stages. So, first you go to this stage. If you're not happy with that stage, you move on to this stage. So then your work as a manager is to bring those steps to the attention of the employee and, provide them with guidance and advice on what their rights are in that regard. So it's very important. If you're the manager who receives a complaint, it's vitally important that you see it through. If there is no policy, there's a general requirement that you can't wish away a complaint, because if somebody leaves your organization on account of not having had their complaint dealt with, they can then raise a claim for constructive dismissal. So even if there's no policy, a procedure can be adopted that is fair, that will enable the employee to feel like they have been heard, the process has been fair, and if they are complaining against somebody else, that person also needs to feel like they have been heard. So I think what I'd want to highlight is just the need for you as the manager to find a way to make sure that complaints that come your way are dealt with in a fair and transparent manner.
Michelle, on the other side of the entanglement.
Yeah, so I would say, just as Anne was saying, a company needs to have some form of policy or take action when they receive a complaint. The same is true in the United States. Even if they don't have a written policy, they are required by law to take certain steps. And if they fail to do so, they could be liable for failure to prevent discrimination or harassment. So what that means is you should expect, if you make a certain kind of complaint, that you may have to participate in an investigation. That's usually the first step that any company will take, is they will either have HR or someone internal conduct an investigation. or they will hire a third-party investigator to come in and do interviews and get documents. And so you should just be prepared that if you make this kind of complaint, there are things that are going to flow from that, and you can't really stop them. You may feel like you are speaking to someone in confidence, but if you invoke discrimination as a reason for being treated differently, technically the company has an obligation to kind of report that and to do something about it. And again, doing something about it usually starts with an investigation. One of the yeah, go ahead.
Wait, so even if I mention informally?
Technically, under the law in the United States, I would say that that is still a protected complaint. And if the company doesn't act on it, they have ignored essentially signs of discrimination, and they therefore knew or should have known that you were being discriminated against. So it's a little bit different if you talk to a peer. That person is not in your supervisory chain. So the company may not sort of need to know or know as a result of you having an informal conversation with your peer. But if you go to HR or even a sort of informal report of unlawful conduct, if you're saying, oh, did you see what Chad did to me at the meeting that felt very racist and misogynist, that felt inappropriate. And if your manager doesn't do anything with that information, ultimately this can all lead into a story of discrimination and retaliation because the company failed to take the steps that they need to, even if you thought it was sort of like an informal complaint. One sort of really important distinction that I think is important for everyone to know, at least in the United States system. If you say, hey, I am dealing with a hostile work environment, I feel like these 5 things have gone wrong for me, and it's been a bad experience. That is not a protected complaint under the civil rights laws, because a protected complaint under the civil rights laws has to invoke the unlawful reason for your treatment. That is, I can't help but feel that I'm being treated this way because I'm a Black woman. I can't help but feel that my peers, who are all men, are being treated differently. You don't need to say, under Title VII of the United States Code, I feel like the protected categories are this, this, and this. You don't have to use those words. You can use softer language, but you do need to let the listener know, or the receiver of the complaint know, that you suspect, or that the issue is that it's racial/gender or disability or pregnancy discrimination. If you just say I'm being treated differently, that isn't a protected complaint. It doesn't invoke the civil rights laws. So that's like the one point that I kind of want to have people understand, is that there's a difference between complaining about a situation and making a protected complaint that invokes the law. And either complaint may result in retaliation, but only a protected complaint is legally protected from retaliation.
And we're going to get to the conversation on retaliation. And are there nuances that are different, or context? Is the law different, let's say in Kenya or in Commonwealth countries?
Yeah, so in Kenya, we don't per se have a law that deals with, employment, protected claims and those sorts of things. What we do have is the Constitution that requires or prohibits discrimination. Then what we also have is the Employment Act that prohibits discrimination in any employment practice or policy. So that normally, if somebody is claiming discrimination, they will be anchoring their claims on either the Constitution. Yeah, they will be anchoring their claim on the Constitution and also on the Employment Act. So it's very important because the court normally will assess the damages, and damages for discrimination are normally significant. So it's important for you to have anchored your claim on a provision in the Constitution to say, yes, my constitutional rights are being breached. And that is also further supported by the provision in the Employment Act. So the most important thing is to anchor your claim on, Article 26 that deals with non-discrimination.
Fantastic. And again, please check on the specifics in your particular jurisdiction. We are missing French law, which I think is a different kind of practice of law, French kind of descended law in this. So please check your particular jurisdiction. Okay. Let's keep it moving. Now, Black women are not always victims. Sometimes we find ourselves accused of wrongdoing in the workplace. And what recourse do Black women have when we're accused of wrongdoing in the workplace, and how can we protect ourselves?
I think the first thing I would want to advise is to seek legal advice. Legal advice, one of the benefits is the fact that you come across as being objective, because most of the time when you receive an allegation like this, you get very worked up, and your objectivity can become a bit screwed. So it's important to seek legal advice, know what your rights are, know what should be done to you, know what cannot be done to you. And that way you're also a bit more objective in how you approach the situation, and very much avoid emotional and rushed decisions. So linked to that is also just asking for time to be able to understand the allegations, review the documentation, and then put together one's response. So it's important to exercise that right. In the Kenyan jurisdiction, it's unfair, and it will be deemed to be an unfair labor practice if somebody comes up with allegations against you in the morning and then you're told in the evening, come for a disciplinary hearing. That's considered a very unfair labor practice. You have to give somebody adequate time to prepare themselves for whatever it is whatever steps are to happen. So ask for time and utilize your right to ask for time. If you feel like the time you've been given is not enough, ask for a reasonable amount. The mistake sometimes people make is they go and they ask for unreasonable amounts of time. Like, for example, you've been given 3 days, you go and ask for 30 days, So it's likely that your employer is going to come back and shorten that period significantly. So, but yes, do exercise your right to ask for time. The other thing is, in the Kenyan jurisdiction, you can also request for the documents that support your employer's claim. So if you're being told that you have been, allegations of harassment have been made against you, you have the right to ask for the evidence that supports those claims. Now, the reality is sometimes employers may not want to give you that evidence, and they know the consequences of that, but you should at the very least ask. The reason why sometimes employers may not disclose that evidence is because they want to protect the identity perhaps of the person who has made the complaint, and they want to encourage people to keep making complaints, so they might not necessarily make full disclosure, but at least ask, make the request for the documents that support the employer's complaint. And then finally, the other thing that I think it's important is avoid making things worse for yourself. So allegations have already been made against you. Sometimes you will find someone will then go and start maybe breaching confidentiality by sending documents, company documents, say to their private email address, or, those sorts of things, trying to incite people against the employer. So it's best at this time to seek your legal advice, do whatever it is that, toe the line, so to speak, and don't do anything that would aggravate the situation. Yeah.
Can I ask, and this is me abusing my privilege here, how do you collect evidence without sending emails to your private email address? And then, Michelle, I'm going to come to you and ask the ZUS if you have anything to add based on context.
Yeah, in most cases, if you look at many employment contracts, there will be a clause that basically says, information that comes to your attention by virtue of your employment is confidential and those sorts of things. So sometimes somebody wants to prove, say, wage discrimination, and then what they go and do then is, maybe you were in finance or you were in HR and you are privy to that information, then that information finds its way into the public domain. Now, you could possibly even go to court and say, the documents that I have are this. There's a procedure that you can use if a matter is in court to ask the court to compel the employer to bring certain documents. So that would be a much better way to go about it than you trying to produce documents, which what the employer is going to do is they're going to apply to have those documents struck off the court record for various reasons, including perhaps even breaching, data protection laws and whatnot. So there are ways that you can legally secure evidence as opposed to trying to do it in a way that will mean your employer is going to come and ask for the documents you've produced to be done away with. So I think that's an important point. If you're in court, many times, like, that's something that has become extremely common, is people trying to send company information, away. And, the company is concerned, is this proprietary information? Is this personal data? Is this information that implicates other people? Is this information that brings out other aspects of the company that are confidential? So it's important that you find the legal way to obtain information that would support your claim. And the thing is that from the Kenyan perspective, if your employer is coming to say that you have committed or allegations have been brought against you for sexual harassment, the burden is on your employer to prove. So it's really for your employer to come forward and say, this is the evidence that I have. And these are the witness statements that we have secured. Sometimes you'll get the statements, maybe they've been redacted. But from a Kenyan perspective, the burden is on the person who's making the allegation. So again, these are some things that somebody would be advised if they seek legal advice. You'll then be able to know, what do I need in terms of the evidence to prove my case.
So, yeah, so I just want to, again, because we're presenting kind of like a wide range of jurisdictions, it's very different in the United States. So the steps that Anne outlined, if you are accused of wrongdoing, you're on the other side of an investigation, are very reasonable and smart. One, find legal counsel. Two, try to get some time to respond, because it isn't really fair for them to force you to respond that same day, for example. And don't make things worse by grabbing documents or breaching confidentiality or intimidating witnesses. All that stuff definitely holds true in the United States as well. What's different and kind of important for you to take away if you're in the United States jurisdiction is that you don't have a right to information from the employer unless or until you engage in litigation. So we're talking about, this is just, you're an employee, there's no court case, they have come to you and said, like, so-and-so has complained that you've been harassing them and been, an overbearing boss. At that point, you as an employee in the US don't really have any rights to information. You can ask. They don't have to tell you. In fact, they don't have to tell you who it is or what the real kind of accusations are. They can just ask the questions that they want to. You don't have informational rights in the United States. You also generally, in most jurisdictions of the United States, you're an at-will employee. That means that they can fire you for any reason or no reason or a wrong reason or an unfair reason, as long as it's not unlawful, meaning discriminatory or retaliatory. And so if they're just like, look, we just believe Joe Schmo and we can't have that kind of conduct, and we looked at one of your emails and we didn't like the tone, they can fire you. That doesn't mean that you have no claims. It may be the case that this whole pattern of conduct evidences racial and gender discrimination. The way that you're not being believed, the way that they've treated you, and it could be part of an entire pattern. But the point is, you don't really have the same informational rights in the United States. The other question about kind of taking documents for yourself, for your case, you do have to be really careful about it. This is kind of a tricky area. The law is really clear that you can't just grab confidential company information and send it to yourself. You can't have like the roadmaps or the financial documents. If you have access to other people's compensation and you're not really supposed to look at it for those purposes, to compare your compensation with others, you could get in trouble for doing that kind of thing. So just be very careful about it and work with an attorney. Certain things are not going to be confidential information. If you get a performance improvement plan from your employer, send yourself a copy of that. You'd be fine to do that. If you get, if you want to take a screenshot of a Slack message or even of some other type of message, if there's not company confidential information in there, you're probably okay doing that, because the company doesn't really have a basis to say, hey, you can't have that, Slack communication where your manager said that one thing, because that's not usually confidential information. But you have to be really careful, because even an email that says, hey, great job, and you want to save that for your files, that entire chain could include a lot of confidential information below it, especially if you're talking about work specific stuff. Other thing just to be aware of, obviously your employer has full access to your work email and your work accounts. So anything you do there, they can see. If you forward yourself an email to your personal Gmail account, they know that. Another way to do it would be to take a screenshot or to print it out. So
Screenshot or print it out. There's a question in the chat about mediation, which we're actually coming to, and mediation and arbitration, which we're coming to. So, Michelle, do NDAs, many of us have contracts that have either NDAs or mediation or arbitration requirements. Do NDAs, arbitration requirements harm or help Black women? And what recourse or options do we have?
yeah, so I just at the top, just to kind of set out these three different types of agreements. First is a non-disclosure agreement. So that could just be the confidentiality agreement, which says, hey, you don't get to take the company's confidential proprietary information. You have an obligation to keep that confidential forever and always. And that's very, very standard. And you just have to be careful that you're not retaining company documents that they're going to complain belong to them and are valuable. Another type of NDA, though, is more insidious, because it basically says, hey, you never get to say anything bad about this company or its employees or officers or directors ever, ever, ever. And that, I think, has been in some employment agreements, but also in some severance agreements. So sometimes when you leave a company, let's say that there's a reduction in force, they offer you 4 months, you sign it. Not only are you waiving all claims against the company, which maybe is fine, but you may be taking on an obligation of never saying anything bad about the company forever. And that includes talking about whether or not the company was racially biased, whether there was a pervasive culture of sexual harassment or gender discrimination, whether they did fail to pay people or engaged in other shady business practices. So I think those kinds of blanket non-disparagement provisions are bad for workers, because everyone should have a right to talk about their experiences at work. There's nothing confidential about whether or not somebody is a sexual predator. In the United States, the law is slowly changing. It's certainly in California, but also kind of on a broader level. As a result of the Me Too movement, which really hit its peak in 2018 and onwards, there's been a more widespread recognition that blanket non-disparagement agreements are bad for victims and bad for kind of developing an equitable workforce. So there are some employers who still have not gotten with the program and have agreements that are still that are contrary to the new laws. So certainly, if you have a non-disparagement agreement, that's something that you want to run by counsel who is experienced in your jurisdiction. The other part is mediation. Mediation is usually voluntary. The mediator has no power to tell you have to accept this settlement, or you have to do this or that. Usually it's just a voluntary kind of participation with trying to settle the case. And so I have no problem with mediation as long as the employer is paying for it, or paying a fair share of it. I think it's maybe a good way to try to resolve disputes. Obviously just make sure that you understand the ground rules going in. Are my communications with the mediator confidential? What information are they going to share with the employer in this process? The last kind of term that we raise is arbitration. Mandatory forced arbitration is a scourge for workers everywhere. I mean, as an executive who is running a company, you may see the benefits of an arbitration provision for your workforce. But I think as an individual claimant, arbitration is bad for workers. One, you waive your right to a jury trial and to a public court trial. Two, the arbitrators are usually retired judges. In the United States, that means that they're old white men. They don't understand discrimination. They've probably never been discriminated against in their lives. They probably went from law school to their law firm to being a judge. And then after they retired, they became private arbitrators. And so I don't think that they have the life experience to understand a Black woman's perspective. Even if they did, even if you do get kind of a woman or somebody who has experienced discrimination, you're only looking at one person's life perspective. That is the one person who's going to decide your case. Usually it's one. It's rare that you have 3 arbitrators in an employment case. And so you don't have kind of the sort of ability to talk to a jury of 12 people or 9 people, or however many it is, to kind of get a calibration of like, who's right, who's wrong, who likes me, who doesn't like me. The last thing too is that arbitrators tend to be stingy with damages. So if you can get out of an arbitration agreement, I would say generally it's good to preserve the option. Because if you sign an enforceable arbitration agreement and you have a claim later, you have to go to arbitration if you want to litigate your claim. Whereas if you didn't sign it and the company says, hey, we have this arbitration program, you still could probably opt into it if you see the benefits of their arbitration program. I mean, the company probably wants you to, and it's an option that you may still have. So if you get an arbitration provision, usually they come with your onboarding documents. Sometimes they come mid-employment, but usually it's part of your kind of onboarding and first day kind of hire stuff. If you can opt out of it, if there's an option, opt out of it. If you can raise it with someone and say, hey, I want to take this arbitration provision out, at least give it a run. If you feel comfortable doing it, it would strengthen your argument that the arbitration provision shouldn't be enforced if you have to fight it later. So I'll stop there.
Okay. Do you still have to go through arbitration if what you're complaining about or your complaint is around discrimination?
Yeah, the one exception is there's been recently an exception for sexual assault and sexual harassment in the United States. Congress passed an amendment to the Arbitration Act. So if you have a case that involves sexual harassment or sexual assault, then you don't have to arbitrate your claims. So a lot of women actually who are dealing with gender discrimination, arguably you could characterize it as sex harassment. And so maybe there's a way out of arbitration through that avenue. That law is still developing. But if the case is racial discrimination, you have to arbitrate it. There's no exception there.
Okay, excellent. I'm worried actually about time, and we only have 10 minutes and a ton of questions to go through. So I'm gonna ask that we just plow through these really quickly. Michelle, what is employer retaliation and how common is it?
So we talked about it, protected complaints. So if you make a complaint that is protected against retaliation, meaning you complain about gender discrimination or race discrimination or some other violation of the law, the employer can't retaliate against you for it. It can take the form of, as we talked about before, all the stuff that you saw with discrimination, ostracism, failure to give you opportunities, petty things like moving your desk or not saying hello to you, all the way up to things like demotions, failure to promote, and termination. I think it's super common. I think that the desire for revenge is almost inescapable. And even the most well-intentioned individual is going to have trouble not retaliating against someone, especially if they're being accused of being a racist. Lots of people, especially white people, and also anyone, recoils from the idea that I'm a racist. No, I'm not. I have lots of Black friends. I hired her, all this kind of stuff. So I think it's pretty pervasive. It's something that you should expect. It can build a strong case for you, but it is just something that often comes with the territory.
To both of you, what can we do about retaliation? Anne, let me start with you.
Okay, sometimes people, in order to avoid retaliation, they decide to make anonymous complaints. So if your organization has an avenue through which you can make an anonymous complaint, you could opt to go that route. Though sometimes you'll find the policy will say, yes, you make an anonymous complaint, but the company decides or has the right to, bring it out to light, so to speak, and have you participate in the subsequent proceedings. So anyway, anonymous complaints. The other thing is to be able to address is just be on the lookout for anything that appears to be suspicious after you have made a complaint, because it's important to get some form of evidence to back up your complaints. And of course, consider legal action if a settlement is not reached here.
Michelle?
Yeah, and I mean, Anne brought this up when we were doing our prep session, talking about documentation, meaning like sending a follow-up email following an oral meeting. And both sides can use that to their advantage. Don't go crazy with it. I would start, if say if somebody said something in a meeting and you're like, you follow up with the email, great. If you start becoming the person who has like 20 emails after every conversation, being like, and another thing, following up per our last conversation, you need to be careful about that so that your tone is appropriate. But that documentation to kind of nail down what people said in real time can be very helpful, because otherwise it can become a he said, she said.
Mm. We're keeping it moving. This tea is hot though. In what ways do you think employers, or are you seeing employers protecting themselves or even going on the offensive or attack?
Okay, so it always starts with the employment contract and the documentation that you get at the beginning of your employment. So it's very important to read contracts. Now, the thing is that most people will not read their contracts through until there are issues. That's when you're looking and saying, oh, there's a restrictive clause here. There's a dispute resolution clause here that mandates arbitration. There's this. So it's important. Employers will always start from the contractual document. So look at those contracts. The other way that employers protect themselves is through the documents that you sign at the point of exit, which could include a discharge. And sometimes that discharge and waiver will be very, very widely drafted in such a way that it will prevent you from subsequently bringing a claim. So it would say you accept X amount in full and final settlement of all and any claims arising out of your employment, and you waive, and it's worded in such a way that will really tie your hands and you won't be able to do anything. So yes, look at the discharges, because they are, from a Kenyan perspective, they're seen as contracts. So it's very difficult to get out of a discharge unless you can prove fraud or misrepresentation or those sorts of things. The other thing is, and Michelle has alluded to this, is of course documentation. You have a conversation with somebody, there's a follow-up, just to avoid those he said, she said things, but also especially when you're having a without prejudice discussion. So in Kenya, without prejudice means I'm going to have this conversation with you. You cannot use this conversation in future proceedings should we not agree. So normally you'll have a without prejudice conversation during out-of-court settlements or those sorts of discussions. So again, you'll find the employer will be quick to write back a follow-up email, which is very clearly drafted as without prejudice. And then finally, mutual separation. So employers will try and use a mutual separation when their case may be a bit dicey. So maybe they don't have a very strong case of poor performance, or they don't have a very strong case of the allegations against you. So they may try to convince you to take the mutual separation route.
Let me just add two things to that. One, the kind of without prejudice concept, we have that, but it's really for litigation, mostly. So just if you are in the US, any kind of dealings that you have with your employer, just assume that could be evidence, and that either side could use it as evidence in the case later. The second kind of thing that I wanted to point out is this idea of the mutual separation. And the waiver of claims upon discharge. I mean, sometimes it's a good thing for you. Maybe your claims, they were going to pay you 6 months, and it's a decent deal. Maybe you feel like you want to negotiate it. But Anne's right that the whole point of it is so that both sides walk away and like there's a finality to it. You sign a waiver and you say, I'm never going to come back to you and sue you about my last employment. And so it could be an opportunity for you, but certainly it is something that can come up. And a lot of people come to me, they're a little bit bewildered by this idea of like, hey, my employer said I could stay and undergo a performance improvement plan, or I could leave and they're giving me this option. What do I do? And that can be a pretty difficult decision for a lot of people. But it is fairly common, at least in California.
Fantastic. As we're going into the last 2-3 minutes of this conversation, I want to encourage folks to take to the chat, to take to the Q&A functions of the webinar. What's going to happen is once we close out this recorded session of the webinar, we're going to go into a non-recorded Q&A session. And now would be a good time to start dropping those questions into the chat, or thinking about the questions that you want to ask our experts to share with us. So just flagging that for everyone. Back to the questions that we did have already lined up for you. What's an employee's right to information during legal entanglements? And what information can we
So
seek?
you're certainly entitled to your personal data. So information that relates to you that's in your personnel file, you have every right to get that information. In fact, it's called the right to portability. You can even get copies of it. So that information is yours. You can get it. And then in Kenya, you have the right to seek the evidence that the employer is relying on to support their allegations. So the employer may decide not to give you, but when the matter goes to court, or if the matter ends up in court, the burden is still on the employer. So they will have to produce the evidence or not produce it and risk the claim being determined against them. So normally that would be one of the things you'll be asking for is, this is the allegation, please give me the evidence.
Michelle, anything to add?
Yeah, it's as I mentioned before, before litigation, before kind of entering into a lawsuit, whether it's in court or an arbitration. In the United States, you don't have that same right to information. In certain jurisdictions, you can get your personnel file, and that usually is just stuff like your performance reviews, your pay stubs, your onboarding documents. But kind of the idea that you get complaints made against you or discussions about your performance, that's in the United States, that's not true. Unless or until you file a lawsuit. Once you file a lawsuit, you have a pretty broad exchange of information, and it goes both ways. You can serve document requests and questions on the company and get a bunch of documents about your employment or about whatever issue. They also can serve document requests on you and get text messages, emails, all that kind of stuff that you've sent about your employment. So
interesting. I'm gonna lump my two questions together, the last two questions together, and ask you to take each to take about 30 seconds and to speak to this. Can you speak to the mental and emotional toll that litigation can take on individuals? What should I expect? How should I prepare? Or should I just quit? Should I just quit this job? Let me start with you, Anne.
Okay, now we normally say the wheels of justice grind slowly. So litigation is a slow process. In Kenya, normally a court case is unlikely to take less than 12 months. Realistically, it will be probably 24 months. So you need to be ready for that. You need to manage your expectations. You're not going to file the claim today and get it heard soon. You need to be ready for what appears to be a very slow process. Yeah, so that's what I can say about that.
Michelle?
yeah, I would agree that it's pretty slow. And in the US, I think a court case usually takes like 2 to 3 years to resolve. Arbitration case, a year to 2.5 years or so. Litigation is difficult. As I mentioned, you have to provide discovery. Sometimes that's an attorney is going through your email account, through your text messages, through your social media, and also you're going to have to answer questions under oath from in a deposition where the other attorney from the other side is like grilling you about various things. Hey, why'd you send this email? What did you intend by this? When you sent this over, weren't you intending to kind of share this confidential information? Whatever the issue is, they're going to twist it in order to make you to win their case and to make you look less credible. And so it can be difficult because, the whole time what you're trying to do is prove like, this is my experience. I experienced racial discrimination. I was treated worse than my colleagues. It was stressful. It caused me to take anxiety pills. Now I have insomnia, whatever it is. All that stuff can like raise all of these emotions and can last for a while. So litigation is not easy. At the same time, neither is walking away from a job and feeling that you have not spoken up or not kind of lived by your ideals. So that is a super personal decision. The other thing that I would say, though, is most civil cases in the United States settle before trial. That it may be that it settles early, and you are only in litigation for a few months, or it may be that it settles on the eve of trial. But the point is, almost all civil cases settle. And so it's rare that a case goes all the way to trial. So that's also something to keep in mind with respect to kind of what does the grind really look like.
Fascinating. Okay. We really want your feedback on this topic and the master classes in general, as we think through what kinds of conversations and how we curate the conversations that we have. So I would just really want to ask everyone on the call. We're not finished yet. We're making a transition. But we really want you to fill in and give us this feedback as we make a transition to a non-recorded Q&A section of this. And I think and I believe that it is possible in the Q&A section section that all of you have access to. It's possible to ask a question anonymously. So if you would prefer, please feel free to do that.